Today we're going to be talking about the benefits of putting your house into a trust. Over the past decade at Rochester Law Center, we've helped thousands of clients estate plan. Some of the most common questions we get asked are about living trusts. In this video, we're going to cover some of the pros and cons of putting a house into a trust. Additionally, we're going to answer some frequently asked questions and address what you can and can't do with your property after you've placed it into a trust. Estate planning is about creating a custom plan to allow you to transfer your money, property, and assets to your family in the most efficient way possible. The two most common estate planning documents are the last will and testament and the revocable living trust. Both of these documents let you specify which of your loved ones should receive your assets after you pass. However, with a last will and testament, your assets must go through probate court before your family can receive them. This can take months, sometimes even years if your will is contested in court. On the other hand, a living trust avoids probate court. This means that your family can receive your money, property, and assets in a matter of days or weeks after you pass, instead of months or potentially years. There are two main reasons why people put a house into a trust. The first reason is that they want their family to be able to inherit their home without having to go through the long, stressful, and expensive probate court process. Instead, their home can be transferred to their heirs in a private setting shortly after their death. The second reason deals with planning for incapacity. It's a common misconception that estate planning only plans for death. Comprehensive estate planning plans for incapacity as well. When you create a living trust, you will name a successor trustee. This person is responsible for distributing your assets to your heirs after you die. They are also responsible for stepping in and managing the assets in your trust if you become incapacitated and can no longer communicate. By putting a house into a trust, you can ensure that one of your most important assets will be managed and taken care of by someone you trust in the event you become incapacitated. In order to avoid probate court, your assets need to be placed into the living trust. This is called funding the trust. When you create a living trust, you are known as the settlor or grantor, depending on what state you live in. When you set up the living trust, you also assign yourself as the trustee. The trustee is the person who has the right to manage all of the money, property, and assets that are placed inside of the living trust. By naming yourself trustee while you are living, you maintain the ability to manage all of the assets in your trust just like you do now. For example, if you plan on putting your house into a trust, you can still sell it at any time in the future. Additionally, you will name your beneficiaries. Your beneficiaries are your loved ones that you want to inherit your money and property after you die. Usually this is a spouse, children, or grandchildren. Lastly, you will designate your successor trustee. Your successor trustee is the person who will take over management of your living trust after you die or become incapacitated. They will be responsible for settling your estate and distributing your assets to your beneficiaries after you die. Additionally, if you are putting your house into a trust, the successor trustee is the person who will manage your home and any other assets you placed in the name of your trust if you become incapacitated. In the next section, we'll talk about all the additional benefits of putting your house into a trust. As we mentioned earlier, one of the biggest advantages of putting a house into a trust is that, unlike a will, a living trust allows you to avoid probate court. There are three main reasons why this is important. First, probate can be very expensive. Probate is the legal process through which the court ensures that when you die, your debts are paid and your assets are distributed according to the law. Legal fees, executor fees, inventory fees, and other costs have to be paid before your assets can be fully distributed to your heirs. If you own property in other states, your family could face multiple probates, each one according to the laws in that state. We usually expect about 10% of your estate to be eaten up in probate court through legal fees, inventory fees, and court costs. For smaller estates, the percentage can be much larger, sometimes leaving little behind for your loved ones. Second, probate can take a long time. The standard probate process takes a minimum of 5 months to complete. However, over the past decade, we've experienced that it generally takes 9 months to a year to resolve simple cases and several years for contested cases. Third, probate is public. Your family has no privacy. Probate is a public process, so anyone can see the size of your estate, who you owe debts to, who will receive your assets, and when they will receive them. The process invites upset heirs to contest your will and can expose your family to greedy creditors and potential fraudsters. A living trust can also keep your financial matters private. Since there's no probate court process when you have a living trust, there's no need to make your assets public. On the other hand, if your house is only included in a will, the will's contents are made public when it is entered into the probate court. Since the trust avoids probate, the contents of the transfer stay private. In general, the only people who will ever see the living trust are the beneficiaries that you name, and even then, only after you pass. The third major benefit of a living trust is incapacity protection. If you become incapacitated during your life, then a living trust can protect your family from undergoing a conservatorship. A conservatorship is when a court-appointed guardian is given the authority to manage an incapacitated person's financial matters for them. This feature of a living trust is especially comforting to families in times of difficulty, since they don't have to worry about going to court and requesting access to the incapacitated person's finances. A revocable living trust gives the family one less problem to face when someone becomes incapacitated. If the trust is set up as an individual trust, then the trustee can take over and manage the assets. If the trust is owned by a married couple, then the second spouse will usually step in as the acting trustee. It's also prudent to have a durable power of attorney for finances in addition to a living trust to grant the new acting trustee the power to manage any property and finances outside of the trust. Putting a house into a trust is actually quite simple, and your living trust attorney or financial planner can help. Since your house has a title, you need to change the title to show that the property is now owned by the trust. To do this, you need to prepare and sign a new deed to transfer ownership to you as trustee of the trust. Before doing this, always consult with a living trust attorney. One frequently asked question is, will I lose control of my home when putting my house into a trust? Not at all. You keep full control of all the assets in your trust. As trustee, you can do anything you could do before. Buy and sell assets, gift them away, and you can even change or cancel your trust altogether. That's why it's called a revocable living trust. You even file the same tax return. Nothing changes but the name on the titles. If you need help setting up a living trust, we can help. Over the past decade at Rochester Law Center, we've helped thousands of clients in all matters of estate planning. Just give us a call today to schedule your complimentary consultation. We offer phone and web consultations in addition to traditional in-office meetings. Let our staff know that you prefer to meet with one of our attorneys in the comfort of your own home via phone or web conference, and we'll get you scheduled based on your preference. Call us today at 248-613-0007. Again, that number is 248-613-0007. Thanks for watching, and we hope to hear from you soon.